it's time for Stan Pierchoski. That's right, and Pierchoski Estate Law.
And Bulletproof Estate Planning.
Bulletproof Estate Planning, that's right.
Good morning, Jeff.
Good morning, buddy.
And it is Friday again. How about that?
It's Friday all over again.
You know, these weekends are coming fast for me, and I'll tell you why. You know, my daughter's moving back this way.
That's right.
And now that's like a week and a half away. That's like a week from this Tuesday coming. Her and the 3 grandchildren will be here.
Yeah.
And I have a list of things I got to do. I mean, I'm trying to do some things plus childproof, right?
Yeah.
And I have a list of things to do, and I spend practically every waking hour or every free hour I have working on it, and the list still gets longer. I get one done and 2 get added. It's like, oh. So it's starting to bother me. So now I have to prioritize and get the. You know, I've been wanting to. I have a stair rail that I want to.
Yeah, you've told me about that.
I want to fix, and I know I had somebody come take a look at it, but I haven't got if I got a bid today and was happy with it, it's too late to get it done.
Yeah.
So I'm doing a makeshift because it's got to be safe.
Yeah.
So it's not real pretty, but at least we'll keep the kids from falling.
Yeah.
But stuff like that, you know. And I got a deck. We have an above ground pool, and I got a deck, and the deck's been there for a long time. I've replaced parts of it over time as deck. You know how decks are.
Yeah, that's right.
And so my wife is going to walk around looking for some boards there's some boards that need to be fixed or replaced. So she's going to go around and make a list of them also this weekend. I'll be doing some of that if I can work it in. Anyway, it's just stuff.
I got you.
And it's not none of it by itself is difficult. Some of it was a little time consuming, but it needs to be done.
Yeah.
But if I prioritize it, I can still do some of it while they're here, of course.
Yeah.
But and I can temporarily do some stuff if it's really a safety thing. But those are the things I want to focus on first. I mean, I don't want to downplay it because I'm happy as can be that they're coming. I just want to make sure, you know, you got. I think we have a 5-year-old, a 3-year-old, and a brand new year-old.
Yeah.
The infant doesn't cause me too much trouble, but the 5 and the 3-year-old, you know how they are.
I got you.
They'll get into anything. So anyway, that would be fun times. And she'll be working at the office with me as she recovers from the birth and everything. So it'll be interesting. So anyway, how's things been with you?
Busy. Very busy.
I know.
Very busy, and I'm not complaining. We like to be busy, and
well, you got to be doing something all day. Might as well be this, right?
Might as well be this. Yeah, might as well be this, and of course, kid activity too. Daniel's always doing something. May's working, and
that's great.
Going in 100 directions always.
At least he's productive. I mean, that's good.
Yeah, we try to be.
No, I mean, child.
Yeah,
that's good. They have that spirit. I know of children that, and I don't want to get off on this, but you know. I see a lot of teens and stuff at the theater, and I know a lot of them. I've probably gone up to 24 of them at one time or another, and I said, look, if you keep doing what you're doing with your phone, you are going to have horrible neck problems when you're about 35 years old or something.
Yeah.
And because you look at them, and they're sitting or standing, and their posture, I mean, your head is almost at 90 degrees looking down.
Mm-hmm.
That you don't understand. If your neck could speak, it would scream bloody murder. You know, and then over time, or back issues. I mean, I don't know. That's going to be something. So maybe if Daniel wants to be proactive, he can start studying how to fix those problems medically.
That's right.
Because there are going to be a bunch of them. I'm telling you.
There is. There really
that
is.
And eye problems.
I think it's an issue already.
That and problems from continuous blue light poisoning in your eyeballs. You know, they don't like that.
Mm-mm.
So anyway, I won't get into that, but what I do want to get into is, you know, we do Bulletproof Estate Planning every Friday from 8 to 9 o'clock on this station, and it is a interactive show.
Sure.
If you'd like it to be, call in. If you have a question, the telephone number is 766-9393. Pretty easy number to remember, 766-9393. And it could be any kind of question. Don't be shy. It doesn't have to be, I mean, don't call in to ask me what my favorite color is or something. But you know what I mean. You make it a question. You can make the facts generic if it's something to do with your family.
Sure.
Understand. If it's really that private and you want to call and talk to me, you can call me at the office and talk to me. We can, you know, that way it's not on the air. But Pierchoski Estate Law, Pierchoski Elder Law, it's 931-363-7222. And you can go to my website, estateplanstan.com. You can ask your question by email if you want. That's the email's on the website, but it's technically stan@pierchoskiestatelaw.com. Also, you can, if you want to look at my calendar when you go to my website, you can see where I'm going to be. And next place I'm going to be with my public seminars that I do is July the 25th. So it'll be in our 250th anniversary month. I don't want it to be around the 4th because I plan on celebrating.
Yeah,
And I
absolutely.
know a lot of other Patriot Americans will want to celebrate as well. And but so we do it on the 25th, which is a Saturday. Saturday seminars we do at 10 o'clock in the morning. We call this seminars Wills, Trust, and the Nursing Home, which is what we talk about, which is what most people want to hear about. And we're going to do it right here at the WLX radio station in the back of the building, where we have a big venue where you guys pick and grin and put a band on every Friday night.
That's right.
People come and dance, and nice big venue. So anyway, I'll bring that up again at the end of the hour. But if you hadn't been to one of my live seminars, you really ought to give it some thought.
Yeah.
Because I get a lot of great reviews on them, and you'll learn a lot. You'll learn a lot. You can ask questions. You can ask as many questions as you want. Take advantage of my time. I give it freely on those things. So, and it's not too early to kind of get on the RSVP list, because last couple of times we were here, we ran out of tables and had just put chairs out without a table.
Yeah.
I mean, we probably could hold quite a lot more people that way, but I mean, you guys got a lot of tables, and when we
do.
exhaust all the tables, and then we start putting chairs out. So
It's a big venue here.
yeah, people will be here. So and again, you will learn some pretty cool stuff. So anyway, if you know anybody that came to it, just ask them. I think they'll probably recommend you do. So I'll bring that up again in the hour.
Absolutely. Absolutely.
So if you don't have any questions, I have some things I'll go
You got
into,
something-
but I
you got
didn't have
something?
any. I had come up maybe a hodgepodge of things, but you know how when we start that way, it's we sort of lead ourselves down the path of something.
Yeah, yeah. Well, somebody's calling in already, it sounds like.
That'll work.
Hey, good morning, you're on with us.
Yes, I have a question. If you have a will in place, which I'm familiar with, and you're going to change it to a trust, either irrevocable or revocable, is there any ongoing fees after you get that set in place, like yearly maintenance fees? That's my question.
Okay. Good question. And I get that question from time to time. I guess the question is if you have a will. Of course, if you have a will, the only ongoing fees you might have with a last will and testament is, maybe 20 years ago you made the will, and now you want to change who gets what, stuff like that, or who the executorship is. And usually when you modify a will, you just usually do a whole new will. It's people don't do codicils to a will. Codicil is an amendment to a will.
Okay.
Don't typically do those because they have the same dignity as the parent document, which means it has to be two independent witnesses and stuff like that. But the question was, if you decide to do a trust plan, you have a will, and you try to do a trust plan, is there any continuing costs? And the answer is no. Basically no. There's no reason to do anything. However, if you have a trust, you may sometime in the future want to modify it. Let's just say, and 99% of the people that do modifications are either in how property gets distributed at death, like to who or what percentages, or the trusteeship, either lifetime or after death trusteeship. Those are the only things that people ever want to modify. And the answer is yes, you can do that. And if it's one of my trusts, if it's a trust that I drafted for you, and then 5 years from now you want to make a modification to it, I do it for just a de minimis cost. It's somewhere around $50, $100 tops, just to make the change. If you bring a trust to me that I didn't author, it's quite a bit different, simply because I have to review that trust to see the authority that you have as the maker of the trust to modify it,
Yeah.
and what it takes to do it, and cite that authority and stuff like that. But if it's one of my trusts, I already know what it takes to do it, and it's just I just charge a little something so I can pay the girls that have to pull it, type it, and do all that stuff.
Sure.
A very, 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 very de minimis kind of fee. So
Sure.
there's no maintenance fee or anything. I know some people say you should hire an attorney every 3 years to review it. I'm not a big fan of that. I do think most people know and understand when you have certain life events that sparks their thought process that might need a change. Like things like marriages, divorces, new births, things like that, where you might say, I left property to my son and his wife. They now divorced. So I kind of want to modify that so the divorced spouse is no longer in the picture. And so that would facilitate a change. Now, a lot of times I can word it in the first place so that that it automatically gets fixed. You know what I mean?
Yeah.
So we don't refer to anybody by name. Just say, if you have a spouse, they get this. But if you don't have a spouse, then they don't get that goes somewhere else. Stuff like that. You can what if it ahead of time and fix it, but nothing like a maintenance fee. I know some attorneys in the forum that I conduct you can buy and pay every year for a membership, and in that membership, if you have an amendment, it's at no cost, but it really is at a cost when you look at it that way. I don't think it needs to be reviewed that often. And like I said, people that bring things to me for changes, they know that whatever happened in life is gonna necessitate a change in the trust, and then they come and say, we'd like to make a change because of this that happened. You don't need to come to me and every 3 years, me ask you questions like, anybody get married, anybody get divorced, anybody get born? You want this all to stay the same as it was? Just to charge you and say, yeah, it looks like it's okay, it can just stay like it is. I just don't, I don't typically do that, I don't think it's necessary. But any fees going forward are very minimal.
Okay.
So I used the word de minimis, which is a Latin term for very small.
This gave me a thought, or for a question, in as far as having a trust. How would you, if you wanted to end a trust,
Terminate, sure.
terminate a trust? What's the procedure for that?
Okay, well, it depends on the kind of trust, but a lot of people use the word dissolve, which is
Dissolve.
not really a legal term, but the meaning is not lost.
Sure.
It's a trust termination.
Okay.
Or the revoking of the trust.
Okay.
Now, I only do two basic kinds of trusts. I do a revocable living trust and I do an asset protection trust, which is an irrevocable trust. Now, so when you want to revoke a revocable living trust, in the trust it says that you the trustor, which is the maker of the trust, okay? So if you do a trust, you and
Teresa.
Teresa, I was going to say Rachel, I don't know why. I just knew it, I shouldn't have said it because it wasn't right, but I'm having my own senior moment there.
I got them all the time.
You and Teresa, you and Teresa would be the trustors, the makers of the trust.
Yes.
And while you're alive, you have the authority on a revocable living trust to change the trust anytime you want and as much as you want. You can amend it all the way up to like 100% amendment, or all the way up to revoking the entire thing so that it no longer exists. So the revocable living trust is a pretty simple thing to revoke. You literally here's what you have to basically do. You got to cite the authority in the trust. There's a document, just revocation of trust. It's usually 1 or 2 pages, maybe 2 at the most.
Sure.
And it says, we're the trustors. We have authority in section 1.04B to amend, restate, or revoke. Okay, and we're here by revoking this trust. Now you have to put in there that you have to make an announcement in this document that you have moved all the property that was in the trust out of the trust or back to the trustor. So if you did a trust, one of the first things we'd put into it would be your house. So
Sure.
we would do that by deed. So the deed would say Jeff and Teresa individuals, quit claim to Jeff and Teresa trustees of their living trust, right? So a trust, you can't terminate a trust if there's still property in it.
Yeah.
It's kind of like a glass of water. You can't turn it upside down until the water's out of it. So when we take the water out, then so we have to make any property that's in it. We have to convey it back to the makers of the trust.
Right.
And then it's empty, and now the trustee has what we call frustration of purpose, because a trust without property is like a nothingness, is a kind of a nullity. So we take the property out of it, and then we just say we are hereby revoking it, and it's gone. Now, the irrevocable trust, a little bit different. The irrevocable trust, you usually have to get the beneficiary to actually revoke it. And again, let me back up. Yes, I am saying you can revoke an irrevocable trust.
Okay.
I know that sounds like legal double talk. It's really not. I think the word irrevocable is an unfortunate name.
Okay.
Because I say that because our trust code, the Tennessee Trust Code, is very, very clear on how to revoke an irrevocable trust. So when you say it's irrevocable, it doesn't mean you can't revoke it. Not sure how it got its name. I know lawyers like to make things confusing, but that's not confusing, that's just incorrect
Yes.
to give it that name. So
Yeah.
maybe there's a history behind it. I just am not interested in researching it to find out. But you can certainly revoke it. It is, but what is irrevocable about it is the makers of the trust. So let's say you and Teresa have one of our asset protection trusts, which is an irrevocable trust. Mm-hmm. If irrevocable meant anything at all, it means that you and Teresa, the makers of the trust, cannot unilaterally revoke it on your own. You have to involve the beneficiaries.
Okay.
You have to have their permission to revoke it. And so with a revocable living trust, you don't need anybody, you the maker of the trust is the only permission necessary.
Okay.
So it's irrevocable by you unilaterally, meaning by yourself.
Yeah.
You have to involve one of the other parties, which
Okay.
is not the trustee, but you have to involve the beneficiaries.
Okay.
But like I said, that's exactly what the trust code says. To revoke an irrevocable trust, you have to do that. You have to give notice to the trustee has to give notice to the trustors that they're revoking it, and then you have to, there's like a 60-day period where you have to wait before you can actually revoke it. And in that time, you need to distribute the property out of the trust back to the trust makers, and you can revoke it. I'm actually in the middle of doing that as we speak. You know?
Really?
Yeah, and I'm actually got some notices out, and I'm waiting for them to come back, the mail card, the green card to come back, saying these people got the notice, and I'm sure everybody's on board because we all talked about it. But yeah, you can revoke an irrevocable trust. So so that's to answer your question, that you can do it, but you got to involve the beneficiaries and get their permission.
Sure, okay. I know you and I have went down this road before, but you've got your trust, and then you've got the asset protection trust.
That's right.
Rightly divide the difference in that just a little bit, because I'm asking, if you don't have what's called an asset protection trust, but you have a trust, are they not still protected?
Well, the whole difference between the two is revocable living trust does not protect the property in it. Okay, but let me tell you what it doesn't protect it from. Of course, it's a probate avoidance technique, and it has all that great stuff about not going through probate.
Okay.
But when you have a revocable living trust, let's look at it from fundamentals. If you come to my seminar, I have two slides in the PowerPoint where I ask you to memorize two things. Okay, and they're very simple things, but they're fundamentals. Okay, and one of the things you need to memorize is if you have access to an asset, so do your creditors.
Okay.
Now, so if you, in other words, let's take you. You got money in the bank somewhere, right?
Yep.
And you could go to an ATM and take money out and take out $100, put it in your wallet, and walk away, right? So you have access to that principal, that property, right?
Yeah.
Now, if you can get at that, another way to think of it is if you can get at it, they can get at it. Okay.
Okay.
So if you can get at that bank account and somebody sues you, and they get a judgment against you, when they try to collect on the judgment, they can go after that asset because it's available to you. It's available to you for that judgment.
Yes, I got you.
That's right. So in a revocable living trust, everything in a revocable living trust, you have 100% access to and 100% control anytime, under any circumstances, for any reason or no reason at all. You can put property in, you can take it out, you can spend it, you can do, it's just unfettered access and unfettered control. You have all that. Okay, because you have all that maximum of loss, since you can get at all of it, if you get sued, or what most people are worried about, and when I say asset protection or creditor protection trust, the creditor 99.9% of the people are worried about is long-term care.
Yes.
Okay, now, so if you owe money to the long-term care facility, they can go after that property in a revocable living trust to satisfy that payment, because it's available to you, it's available to them.
Okay.
So the asset protection trust is a slightly different animal. It is a trust, and it acts like a trust, but it is an irrevocable trust, and we're gonna limit your access to the principal. Okay. Now, when I say that, people think, well, that means I'll never see it again. I can't use it. I can't get at it, and not so. This is structured in such a way. I'm not going to do it justice in this short time on the radio, but I talk about it at the seminar. We have a PowerPoint and a little more of a visual, which helps. But the asset protection trust, once you put property into it, the trust itself says you, the maker of the trustor, so it'd be you and Teresa, have no access to the principal. Now, when I say that, it doesn't mean you can't ever get at it. Access is a legal term. It means you can't get at it a very specific way.
Yes.
So what access is defined as, and I'll do the best I can without my whiteboard and a visual to look at it.
Okay.
That helps a lot. But if you draw a box, if I'm on my whiteboard and I draw a box and I say, here's your trust, and we give it a name, okay, and we move property into it. So I draw a little picture of a house in there, and then I'll draw like a bag of money with a dollar sign on it. That represents like a bank account, okay? So once you put property in there, this trust is saying you, the maker of the trust, have no access to the principal. Now, you have to understand the difference between principal and income. Most people do. So, like the house, okay, or let's say the house is worth $500,000. That's the principal of the house.
Yeah.
If you're renting a room and you're making $500 a month, that's income, right?
Right.
That's the difference. Now, I'm not going to talk much about income because that's okay for you to get, spend, do whatever you want with. That's where it gets its name, income only asset protection trust. But what we're going to do is we're going to lock down the principal. Now, what we're really locking down is this. Let's say you have a bank account with some money in it, because it's easier to talk about doing what I'm going to talk about doing than taking a chunk of real estate out of a deed. Okay.
Sure.
So you got I don't know, $100,000 in a bank account that you put into the trust.
Yeah.
If any of that money comes out of that, so let's just say, let me do an example. We put it in there that says you, the maker of the trust, have no access to the principal. But let's say you put that in there, and when I advise people, I say, when you're going to put a bank account in this trust, let's put something in we do not contemplate needing to live off of. Okay, so we put it in, and you say, you know what, I got this $100,000, it's an investment thing, I'm just letting it percolate, it's going to go to the kids someday,
Yeah.
I don't need it. So you put it in, a couple of years down the road, something happens that you weren't expecting, tornado goes by and takes off half your shingles, right?
Yeah.
And it's like, okay, I need $30,000 to fix the roof. I didn't see that one coming, but I think I need money out of that bank account to
Yeah.
pay that, because it's
Yeah.
going to really disrupt my cash flow, right?
Yeah.
Well, it doesn't mean you can't get at that money. Here's what you can't do. You can't take money out of that bank account that's in the trust and go directly to you, the makers of the trust. That's what access means.
Okay.
Money coming, sometimes you'll see it referred to, if you interneted it all, as direct access.
Yeah.
That's not really the right term, but it helps understand it.
Sure.
If a principal comes directly out of that trust to you, the maker of the trust, or either of you, that is access. Now, the reason and that's what can never happen. Okay, and here's why it can't happen. And the language in the trust is very, very strong that you have no access to it. And actually, if you would read one of mine, you'd say, this is borderline ridiculous, all this no access, under no circumstances, no way, Jose, not a zip. I mean, very strong language, and it needs to be that way.
Yeah.
And so here's what can happen. If you, let's say that, I'll fast forward some years, and you're in a nursing home, okay? You're trying to apply for benefits, right?
Mm-hmm.
When you apply for benefits, when you send in your application, they're going to scrutinize your resources, and so they're
Right.
going to know you have this trust, because they do their own searching, and they'll see your house is titled to it, right?
Right.
And they'll ask for it. Can we please see, the Hood Asset Protection Trust?
Right.
And you have to send it to them. You can't hide the ball. So
Right.
we send it to them, and I don't have a problem with it if it's one of mine. I'm glad to send it to them. And what they're going to do is they're going to look at it, and they could say, what happened 10 years ago when this $20,000 came out of this bank account? Where did it go? If the answer is, well, it came out of the bank account and it went to Jeff, one of the trustors, he went and paid the roofing bill or a medical bill with it or whatever, okay? They're going to say, oh, I see where the trustor had access to the property in the trust. Now we have access to it. That will taint, if you do that, that taints the creditor protection we're trying to build in.
Right.
So, now it doesn't mean you have nothing to do with the property, because we're also going to say you maintain infinite control over the property. So I'm going to use an example for that that's right down your alley.
Okay.
And that is, let's say you put this $500,000, or your house.
Yeah.
We'll say it's worth $500,000. If that's low, I'm sorry. If it's high, you don't get a windfall.
There you go.
But for example, if it's $500,000 house, you put that in the property, put that piece of property into the trust, asset protection trust. A couple of years from now, you wake up in the morning and you say, screw it, we're moving to Florida.
Yeah.
This crazy Tennessee weather or whatever. We're moving to Florida. Well, the question now is, can I sell this $500,000 house that's in an irrevocable trust with no access to principal, right?
Yeah.
And the answer is yes. Sell it. Call your realtor, call your partner and say, hey, I forgot his first name.
Oh, Hester.
Hester?
Yeah.
Call him and say, hey, I want to sell the house, put it on the market. So he lists it on the market, you get a buyer. What do you get when you sell a $500,000 house?
Money.
It's not a trick question. You get the money. Good job. Good. That $500,000 has to stay in the trust to stay creditor protected. So if I draw this box on my whiteboard and say, here's your trust,
Yeah.
and I draw a little stick figure of a house in there, and $500K underneath it.
Yeah.
Let me erase the little house, but leave the $500K there. So the money has to stay in the box or in the trust to stay creditor protected.
Okay.
So here's what that would look like. You get to the closing, okay? You and Teresa are at the closing, and you say to, oh, wait a minute, don't make the check out to Jeff and Teresa, the individuals.
Yeah.
If you do that, it's outside the box. It's available to us. We can access it, so they can access it.
Yeah.
Right? So we would have taken a protected house and unprotected the money.
Yeah.
Because you got to think. You don't think about a house. It is an asset. It has value.
Right.
And that asset never left the trust. It just changed posture.
Yeah.
It was a piece of real estate for $500,000. Now it's money for $500,000.
Right.
So you say, make the check out.
I got it. Yeah.
Make the check out to Jeff and Teresa, trustees of our trust. Now it doesn't leave the box. You get to Florida and you buy a new house, here's what that closing looks like. You say, well, wait a minute, don't make the deed out to Jeff and Teresa, the individuals. If you do, it's not in the trust, we have access to it.
Yeah.
Make it out to us as trustees of the trust, so now your new house is titled just like the one that was in there that we sold.
Yeah.
Now, we have manipulated, we have had control over this piece of real estate. We've changed it, we've modified it,
Yeah.
and we've never had access to it because it never came out of the trust. So we didn't have access, but we controlled it. Have you ever heard anybody say something to the effect that I want to own nothing but control everything?
There you go.
This is what we're talking about.
Yeah, I
and there's
got
an advantage to that because I like to, if you don't own it but you control it, I like to explain it like this. I don't need money. I need a house to live in, correct?
Yeah.
I don't need money. I need the house to be cool in the summer and warm in the winter, right?
Yeah.
I don't need money, but I do like to eat three squares a day, sometimes 4.
Yeah.
I do like to eat, right?
Yeah.
I don't need money, but I like to wear decent clothes.
Yeah.
You see where I'm getting at?
Yeah.
You don't own it, but you have all the benefit of it.
Yeah.
The trust owns it. The ownership has changed from you to the trust when we do that. Now let's take that bag of money that's in the trust, which is a bank account. Let's say it's $100,000 in the bank and you say, you know what, this isn't doing squat. I want to put it in cannabis stocks. I think they're going to take off. You can do that. Buy the cannabis stocks. I want to put it in the CD. I want to put it in gold, or I want to put it in an Edward Jones managed account, or something, right?
Yeah.
Whatever, you can change it every day of the week or never at all. But whenever you change it, you still have to change, make sure that it stays titled to the trust.
Yeah.
But you can modify it as often as you want or never at all. So if I decide to get a CD, I go to the bank and say, I got $100,000 in the bank here, I want to buy a CD with it. As they're filling out the paperwork, they'll say, who's the owner of the CD? Jeff and Teresa, trustees of our asset protection trust. Okay, now you've modified it, you've changed it. So if you got let's say we have $600,000 in this trust, 500 house, $100,000 bank account, right?
Yeah.
If that 600,000 is always there, it's always protected. It doesn't matter if it changes posture from real estate to cash, back to real estate again, to gold,
Right.
to a CD. As long as it's in the trust, it's protected. Okay, and so you get the best of all worlds. You get the protection and all the use and control. Like if you put your house in there, you don't have to move out of it or something like that. Actually, if you put your house into the trust, it is 100% seamless to you. You still, if you have a mortgage, you still got to pay it. If you have taxes on the house, which every February 28th you do, you still have to pay it. You got to mow the grass, you got to clean the gutters out. I mean, nothing changes to you as the homeowner. It's just, except for the ownership is now the trust instead of you, the individual.
There you go. Smart doing.
I mean, so, and now, let me just make this clear, because somebody once got the wrong impression and called me. When we talk about creditor protection, you can do this. You can put property in this trust and protect it from your creditors, but it has to be a future creditor.
Yeah.
You cannot defeat an existing creditor. Now, here's an example. Let's say you have a mortgage on the house.
Yes.
Or in Tennessee, they call it a deed of trust, but it is an indebtedness, right?
Right.
And you put your house in the trust. You have not defeated the bank's remedies one iota. If you stop paying, they can put the house up, they can foreclose, right?
Right.
You cannot defeat an existing creditor. Now,
That's
when we
right.
talk about long-term care, for 99% of people, that's a future creditor.
Yeah.
Now, if you're already in or in crisis, kind of like your father-in-law was,
Yeah.
well, it's a little too late to do the trust. There's other things we do then.
Sure.
The crisis planning tools. But the thing is, if you want to protect your real estate, do this trust, put the real estate in it, and it's a done deal. They cannot get at it. Here's why. You have no access to the principal, right? So let's say we got that $500,000 house, $100,000 bank account in the trust, just like before, right?
Yeah.
And you're in the nursing home, right? And they come to you and say, Jeff, this is $10,000 a month. You can pay us out of this bank account in this trust. You got $100,000 there. Your response is, and I would point to where I wrote on the board, no access to principal. I'd say, I can't pay you. I couldn't pay if I wanted to. I don't have the authority to write a check on this bank account.
Yeah.
Because by terms and conditions of the trust, I have no access to it. I can't. It is not available to me to pay you.
Yeah.
In translation, when we talk about countable assets, you hear people talk about countable assets.
Yep.
The minute we moved it into the trust, the very instant it changed ownership from outside the trust, that $100,000 was a countable asset.
Yep.
And a lot of times I tell people, if you don't understand what countable asset means, insert the words available for cost of care asset.
Right.
So if you have a bank account in the bank, it's available for you to pay them.
Right.
The very minute you move it in the trust, it is a non-countable asset. It is no longer available to you to make payment. That's the protection you get.
Right.
And you get the best of all worlds because at death, even whether you're in the nursing home or not, everything in the trust just distributes to your heirs the way the trust says to. It has all that stuff that all trusts do, which is probate avoidance and all that. You know, how it goes to people and dictate terms and conditions. So it's really a grand planning tool. And we're so fortunate to be able to do it here in Tennessee because our trust laws about these very trusts are very favorable in Tennessee.
Right.
Is somebody knocking on their door?
Yeah, but they'll have to wait. Hey, buddy.
Oh, it's one of your, okay. I was looking too high. That's one of the children. Does he need to come in and
No,
give Dad a hug?
Yeah, that's not one of mine.
Oh, okay.
Hey there, you're on with us.
Yes, I've never heard him address this, but now I've missed a couple of times, you know, handyman and stuff. But my understanding is Social Security cannot be put into a trust, or that you have to have some kind of special something set up if it's over a certain amount. And this came to mind because of your the person you had on Wednesday discussing Medicare. So let's say if you get Social Security and it was over the maximum amount, how would that be handled? Isn't there a special something that you have to, a bank account or a special arrangement? I just read that it was very complex, but the Social Security checks could not go in to the trust or the whatever.
All right, well, I'll let him talk about that. Very, very good.
Yes, I know exactly what
That's an
she's talking.
interesting question.
I know exactly what she's talking about, and it's excuse me. I know what she's talking about. It's really not that complex, at least not for me, because we do it a lot.
Yeah, you do it all the time.
It's kind of routine for me. What we're talking about, when you talk about Social Security, first we got to talk about, understand what that is. That's not a resource. You don't own that. It is a stream of income.
Yeah.
Okay. Now, if you want to get, and now she talked about Medicare. Okay. Now, Social Security has nothing to do with Medicare. But she mentioned somebody that was talking about Medicare, maybe they mean Medicaid.
Yes.
Which is long-term care, right?
Right.
So when you're dealing with long-term care, and when I say dealing with long-term care, I mean trying to get eligible for it. You remember when your father-in-law, we got him eligible.
Right.
To get somebody eligible, they have to be income eligible and they have to be resource eligible. There's two different kinds of assets.
Right.
One is a stream of income. You don't have any ownership in it until it actually comes to you. So let's say you get $2,000 a month of Social Security, you don't own it until you get the check.
Right.
Okay. And it's income, which is what you spend to live off of.
Sure.
So you have $200,000 one day, you spend it, and the next month another $2,000 comes. That's the theory, right?
Right.
Resources are what you own. Your house, the money in the bank, your cars, your stuff, right? That's ownership. Now, so we're not talking about resources, we're talking about income. Now, to be eligible in the state of Tennessee, we are an income cap state. What that means is the income is capped. You cannot have more income than $2,986 a month.
Yes.
For 2026. I think that's right. Anyway, it was $2,902 for 2025, and $1. I think it went to 29, either 46 or 84. Maybe my dyslexia is, but anyway, a little bit. 29 something and some change. And now, if you're over that, you're technically ineligible under the income thing. You got 5 categories we gotta be eligible in, and it's no good to get 4 out of 5. You still lose. Okay. One is you got to be an United States citizen. That's usually a gimme. 2, you got to be a resident of Tennessee. That's usually a gimme. 3, you got to be medically needy, which means you got to have a medical reason to be in a facility.
Yeah.
We don't just check ourselves in so we can play Parcheesi with the guys, right?
Right.
You got to have a medical reason. I don't have much say in those first 3. But the other 2 is where we spend you got to be income eligible and you got to be resource eligible. So we're going to talk about income eligibility. All you need to do to be income eligible is have income under the cost of care. All right. Now the cost of care is about $10,000 a month. So now is that conflict with what I just said? So let's say you have $7,000 of income.
Yeah.
Okay. Well, the cost of care is $10,000, right? So
Yeah.
it's less. So that'll make you eligible. But wait a minute, Stan. You just said if you have over $2,948 a month, you're busting the cap, and that's true. But it's a simple thing to fix. If your Social Security, or not just Social Security, if your collective income, because many people get Social Security plus a pension.
Yeah.
So if your collective income exceeds the cap, but not the cost of care, we can still satisfy the income eligibility, because what we're going to do is open up what's called a QIT. It stands for Qualified Income Trust. Many banks and many people refer to it as a Miller Trust. It gets its name from common law jurisprudence, where the court said, it came from a court decision, and Miller was the commissioner of Medicaid at the time, okay? So, you take this, what this trust is, it says let's say, make a nice round figure and say, we get $3,000 worth of income. It's over the cap and it's less than the cost of care, right? And that's it's kind of a reasonable number for what kind of people get, somewhere in the 2,000 to 3,000. So you get $3,000. Well, we busted the cap just by, I don't know, by $25, right? Or $29.84 or $25.48 or $50, $25. We're over the cap. That of and by itself, that's a disqualifier under the income status. But if we open up a QIT and take whatever's over the cap and put it into and a QIT is a bank account. You go to the bank, say, "We'll open a QIT." It's technically a trust, but it works. It is a little trust, but we're putting this bank account into it.
Okay.
And the trustee will probably be the person's power of attorney, typically. So like when your father-in-law was in there, we made Teresa the trustee of the trust. I think we did.
Yep.
And so then what the theory now is, the theory is when you're in long-term care, all your income goes to the cost of care.
Yes.
That's a general principle. Now, there are a few things we can take out. I'm not going to muddy the waters with that, but you can just take out what you pay for your Medicare, which is usually deducted anyway when when you get up there. And you take out like $70 a month for personal needs allowance. But the general rule of thumb is all your income goes to cost of care. So if you have $3,000, it's all going to the cost of care, but you're over the cap. So the way they let us fix that and still become income eligible is whatever's over the cap, we're going to put into the QIT bank account. However, all your income, so you kind of write two checks every month. One was all your income, and two is the stuff that's over the cap from the trust, because in that trust, the terms of that trust say, any money put in here is earmarked for the cost of care. You can't take it out and go to the movies, or something like, what I mean? It's got to go to the cost of care.
Okay.
What it does, I think it's kind of ridiculous because it's all going to the same place. Why don't we just do that? But to satisfy the rules, we can be over the cap if the terms of the trust make sure that anything over the cap goes to the cost of care. Because here's what they're worried about. If you have a lot of income, they're worried, okay, we're going to pay for your bill, but if you have over the cap, then that's just money you're going to have to do anything you want with. Party, spend. They kind of over-resource you. If we put in this it's an irrevocable trust, and once you put in this trust, it's got to go to the cost of care. And so now there's no way for it to ever come back to you. So they're okay if you do it that way, because you can't reap the benefit of the extra money that you have over the cap.
All right.
So that's what. So she talked about putting Social Security in a trust. You couldn't put Social Security in a trust anyway, because you don't own it. You got to own something to put it in.
Okay.
I mean, let's say you have let's say you put a bank account in the trust. Well, that's great. You own money in the bank account.
Yeah.
But if you get a $2,000 Social Security check and you only spend $1,500 of it, and you bank $500 of it, you put it in that bank account. You can put that in the trust that way, but you can't put the stream of income in the trust.
Are you allowed to keep any income at all for personal expenditures?
The income, the rule is all the income goes to cost of care, but here's the things you can take out. What you're paying for your Medicare. Now, that is usually automatically deducted from your Social Security. Now, I'm talking about the Part B, right?
Okay.
Now, if you have a supplement, which everybody should have,
Sure.
they'll let you take out the money it takes to pay for the supplement. So your medical insurance you can pay for. And you can take $70 out every month for a personal needs allowance. God bless them, you can have $70 a month. Now, what you can get for that is not much. You maybe get a haircut. I don't know, but
$70 a month, really?
Yeah.
That's all you're allowed to keep for
personal needs. It's called a personal needs allowance. Yeah.
Okay.
Theory is this: if you're in a long-term nursing facility,
Uh-huh.
well, let me take this back up. If you're not in a facility, you get income, right? And you're buying food with it. You're sheltering yourself. You're buying clothes with it. You're living under that income, right? If you're in a nursing facility, they're doing all that for you. So all your income goes to them because they're housing you, they're feeding you, they're stuff like that.
Okay.
But they let you take out what's necessary to pay your insurance, which is the medical insurance, which is Medicare, and any supplements for Medicare, which most people have a supplement. So you can pay all those because we do want to keep that because that is insurance. That's not long-term care. That's insurance. And you can take out that $70. And to be surprising, just last year in 2025, they raised that from 50 to 70.
Really?
It was,
Wow.
Yeah,
See, I was thinking, of course, I was wrong. I was thinking it was a couple $100 a month that was available to you.
Some states it is, but not here.
Not Tennessee.
Yeah.
Okay.
So, hope that answered the question because
Wow.
it's if you over a certain amount, she mentioned being over a certain amount, that's a problem. It is a problem, but it's easy fix. The QIT, Builder Trust, you just have to put the now. What happens sometimes, the terms of that trust say this can go no place but of cost of care. That's what makes it work. Okay. Now, but it says in there that and the first beneficiary of this QIT is the Bureau of TennCare, because if you're getting benefits from them and they're paying your bill, and if you pass away and there's anything left in there, they get it because they've been paying your bill. Now, but the second beneficiary are the heirs. So you name, in your case, in Teresa's case, you would name her the second beneficiary. Now, let's suppose somebody's got this QIT and maybe we're in a penalty period or something and we pass away. Well, we've never had TennCare pay anything for us yet because we're in a penalty period, we're private paying, we're doing one of those Medicaid compliant annuities, right? So we could possibly pass away with quite a bit of money in that QIT.
Yeah.
Well, what we do is we send off the TennCare for a release on the estate, and they'll give one. Then we send a second release off to ask them to release the QIT because TennCare never paid anything for this person, so they have no claim on it. So we get that release from them, then we show that at the bank, we can say, how much is in the QIT? $5,000. Well, I want it. Now it's not going to the cost of care because the person passed away, and TennCare does not, the first beneficiary has no claim on it. And so now it can go to the next beneficiary, which is the family.
Interesting.
So yeah, I mean, that's the only time it doesn't go to the cost of care, but it only goes to the cost of care because they're paying and they want paid back.
Sure.
Which is the whole concept of estate recovery. Now I'm shifting gears now. Estate recovery, here's something that shocks people. I mean, you talk about sticker shock. I'm gonna throw this out here because it will probably infuriate you. And if you got somebody in care, you need to know this. And that is, if Aunt Gertrude's in care, and you say, you know what, let's fill out the 16-page TennCare application and get them eligible. Okay, and let's just say, let's fast forward through all the stuff.
Yeah.
Okay, that you're going to run into, and let's get to the end and say they approve. And so Aunt Gertrude's in a nursing home. It costs $10,000 a month. She has $2,000 worth of income. That goes to them. TennCare pays the other $8,000, right?
Yep.
Let's say you're doing that for a year and a half. You rack up a bill of about what, $200,000, let's say?
Yep.
Okay. Aunt Gertrude passes away. Now, most people think that once you qualify for TennCare, the burden is the state's, right?
Yeah.
Well, first thing you'll get after Aunt Gertrude passes away, you get a letter from Estate Recovery going after everything she owns. And they will give a list, 32-page list of everything TennCare paid for her.
Yeah.
And they say, we have a claim on her primary residence, or anything in her estate, which is typically the home, for $250,000.
Yeah.
So what they're saying is, when you got them eligible, they didn't tell you it was a loan, did they? And after death, they want paid back. Now that just shocks, that makes people's hearts stop when they get
Yeah, it does.
They can't, why? What are you talking about? We got eligible for TennCare.
Yeah.
What do they want all this money back for? Well, that's the way it works.
Yeah. That's the way it works.
And so estate recovery is something we really go out of our way to avoid.
Yeah.
And there's a way to avoid estate recovery and not have these assets available for them to come after. Enter the asset protection trust. There's a couple other ways to do it with our crisis planning tools, but the very, very best way to do it is with the trust, because the most important thing to get in this trust is the real estate.
Yes.
If you come to me in crisis, if you come to me and say, Stan, Teresa's in a nursing home, I don't want to lose our house, right?
Yeah.
Real estate is one of the hardest things for me to protect at the last minute, if you hadn't done anything ahead of time. I can do it, but it's cumbersome, it gets pretty expensive, and it's drawn out.
Yeah.
It's a real dotting the I's and crossing the T's thing. It's a real legal thing to do, and it'll be scrutinized, so it has to be done just right. It can be done, but the better thing to do is put it in this trust, and now it's the minute you put it in, it escapes estate recovery.
Yeah.
Because it's now in a creditor protection trust, and estate recovery is a creditor. They can't get at it. They can't get at it because you don't own it. They can go after whatever you own at death, and you don't own it, the trust does. I mean, and you might say, well, am I defeating, if I owe it, should I really have to pay it? The answer is, I guess my question would be, do you really owe it? I mean, this is nothing new.
Yeah.
This is nothing new. And one of the key features is the creditors have to be future creditors. They don't exist yet. Now, you cannot defeat an existing creditor. That's
Yeah.
the goal. Now, it's just like taxes. Suppose your tax guy said you got hammered last year, but if you take this money that you got in the bank, you got $100,000 in the bank. If you take this money in the bank and you put it in this posture, you invest in this thing, I can say you won't have to pay as much tax as you paid last year, right?
Yeah.
I mean, I'm not a tax guy, so I'm just spitballing, but I know there's things you can put money into that mitigate the tax bill, right? What's the same thing? If you can't screw, I mean, let's use street vernacular terms. You can't screw an existing creditor. And that's what that would be, and the law won't allow that because it's self-serving. The reason I want to make a big deal of that is I got a call one day from somebody that said, hey, I got sued, got a judgment against me for $200,000. If I put my stuff in this trust, would it protect me from them? And I said, no, it will not.
It will not.
They exist. That is working an unfair tort against that creditor, and the law won't allow that. But a future creditor, no harm, no foul, right? You're
Right.
just structuring your financial situation to make it so it best fits in your best interests.
Sure.
And the courts have said that. That's not just me. I mean, I have one of our appellate court cases where it talks about this very trust that I do.
Yeah.
And one of the POA made the trust for his mom. And it did exactly that. They dealt with state recovery, and the court said to create an asset protection trust to avoid the high cost of long-term care is certainly a beneficial tool to use, and is certainly in the trustor's best interest to do so. So we got the court's sanction here. We're not screwing anybody out of anything. That's
Right.
the law.
Right.
I mean, the only people you could screw out of it is you already have a creditor. You don't know if you're going to have any future creditors. You might have one with TennCare, but we don't know.
Yeah.
But it's just like taxes. When your tax season comes up and the IRS says, hey, we want the same money as last year. Well, you're not going to get the same money as last year because we took $100,000 and put it in this, and we don't have to pay tax on that. And the IRS says, oh, okay. They'll look at it to make sure you did it the right way.
Sure.
And they'll say, okay, so you owe us less now. You're not screwing anybody anything if you're following the legal procedure.
Exactly.
And these trusts have been around forever. They just became more and more popular in the mid-'60s when we adopted the Medicaid Act.
Okay.
They've been around long before that, the creditor protection trust. It's the common law jurisprudence that if you're a future creditor, you don't have any rights in somebody's assets. If you become a creditor and you're worried about that, then you might want to ask about all that before you become a creditor of that person. But I mean, so it works like a champ. I mean, I've done enough of them for them to mature, where I send them off to TennCare, and they look at them. But then, I know exactly, when I send the trust to TennCare, I know exactly what they're looking for. You know what they're looking for? They're looking for that thing I said where you have no access to principal. They're looking to see if the trustor has access to principal.
Right.
And if it's one of my trusts, they're not going to find it. All they're going to find is this over-the-top language I mentioned earlier.
Sure.
That says not only do you not have access to principal, if there's anywhere in here that even looks like you have access to principal, this enabling clause in the beginning says it's not access to principal.
Yeah.
It's that strong language.
Sure.
And when they see that there's no access, they say, okay. But the reason they're looking for that is there's a lot of attorneys out there that do these kind of trusts, and it's what my wife calls stay in your lane. Teresa ever tell you to stay in your lane?
Stay in your lane.
Well, if you don't know what you're doing, and there's a lot out there where people they'll draft these trusts for them, but they'll put language in there like, okay, if either Jeff or Teresa have a catastrophic illness and they gotta get at the assets in this trust because it's a life or death situation, they can get at it. Guess what that is? That is access.
Open door.
That is access.
Yeah.
If you have access, now they have access. You haven't gotten anywhere. Or you might say, what I didn't get a chance to cover, and we're running out of time, was if you ever want to get property out of this trust, you can. You just have to distribute it to one of your lifetime beneficiaries who can turn around and use it on your behalf.
Sure.
That's how we get the money to fix the shingles that blew off the roof
Sure.
out of there. But I cover that heavily at the seminar. Lost my train of thought. I was hurrying up because I was looking at the clock.
That's
But
okay.
I was talking about TennCare looks at. They're looking to see if it's done right. If it's done right, they don't get mad. They know how it works.
Yeah.
I mean, at least the legal division knows.
Yeah.
They know how the trusts work. But there's a thing called the Age Blind and Disabled Manual, which is the TennCare manual. When you talk to a TennCare caseworker or an attorney, that's what they go by.
Interesting.
And I've got that. And it has examples in there. It talks about trust, talks about this very trust. It says if it's this, and this, they're non-countable.
Yeah.
But if it's this, and this, but not this, then it's going to be a countable asset.
Gotcha.
You got to do them right.
Interesting.
And to do them right, takes a little bit of time, energy, and effort on your attorney's part to understand how it works. Because it's a voluminous set of laws.
Yep.
And most attorneys don't spend the time, energy, effort to understand them.
Yep. Got about, a minute and a half.
Yeah, that clock's getting farther and farther off. It says,
Yeah.
well, it says 3 minutes.
Yeah.
Okay.
Got about a minute and a
Well, let's
half
just
here.
talk about the seminar coming up
Yep.
again. It is on July the 25th. Last one was just in May 30th. We do them every other month. July the 25th, it's a Saturday. Saturday seminars, we do at 10 o'clock in the morning. We call it Wills, Trust, and Nursing Home. I will talk a lot about this very trust because it is very popular. And that is a Saturday, 10 o'clock, and that is going to be right here at the WDXE radio station. And if you're not familiar with the radio station, the physical address is 1212 North Locust Avenue here in Lawrenceburg. It's the back of the building. I don't even think the front doors by the radio station will be unlocked on a weekend, but there's a door in the back, double door in the back.
Right.
I like to say, if you look for the biggest tower in all of Orange County, you can't miss it.
Yeah.
It's kind of like the end of the rainbow. If you go where that tower hits the ground,
Yeah.
there's a set of double doors right there. That's the right place.
That's
You
good.
guys call it the country kitchen, but there's no sign, so I hate to say that.
That's
I
right.
don't want somebody looking for the country kitchen sign. Or they might ask somebody who's not familiar and say, I never heard of it. So, but anyway, you want to RSVP for that and talk to me about anything we talked about. Call me at Pierchoski Estate Law, Pierchoski Elder Law, 931-363-7222, or go to my website, estateplanstan.com.
EstatePlanStan.com. That's easy to remember. And that phone number too, 363-7222, located in Pulaski, Pierchoski Estate Law, and Bulletproof Estate Planning.
I appreciate
We'll be
the
back next Friday.
And I appreciate the questions. If you got some, formulate them and call in and ask.
All right. God bless, buddy.
Always a pleasure. That just flew by. I don't know if it